Good morning. Normally, whenever writ challenging authorities' orders are being filed, writ of certiorari, the Honorable High Court of various states mechanically dismissing if other side says there is a provision to prefer appeal. So this issue was pending disposal of the Honorable Supreme Court. And finally, the Supreme Court on 1/2/2023 held AR 2023 Supreme Court 781. AR 2023 Supreme Court 781. Messrs. Godrej Sara Lee Limited versus Excise and Taxation Officer cum Assessing Authority. In this case, the Haryana Value Added Tax, VAT, wherein the authority by suo motu revision power passed some orders, against that he can prefer an appeal. Therefore, the writ petition filed by the company was dismissed for want of maintainability since appeal provision is there. The Supreme Court now says ground of availability of alternative remedy cannot be mechanically be construed as ground for its dismissal. That's what they say. So you writ courts should not dismiss mechanically on single ground that appeal remedy was available, alternative remedy was available. But in the given case, it is because of the complicated provisions of the Act. Assessing officer may pass some order, subsequent the superior authority may suo motu revise the tax, enhance the tax. That may be, you can prefer appeal, all those things. See, the problem was, or filing appeal, the assessee has to deposit certain percentage of the tax. That is why they prefer these sort of writ petitions. So this court, the Supreme Court now come to rescue that the alternative remedy, if available, still the courts can entertain their discretionary power under Article 226 of the Constitution of India. The Whirlpool Corporation versus Registrar of Trademarks, Mumbai and other case, wherein this court has held, where the writ petition seeks enforcement of any fundamental rights, where there is violation of principle of natural justice, where the order or proceedings are wholly without jurisdiction, where the virus of an act is challenged. That time writ may be. So what you have to, you should not harp and argue that your client was improperly dealt. No, instead of that, you have to state all these grounds at the initial stage itself, that the fundamental rights of the persons was infringed by the impugned order, and the principle of natural justice not given proper opportunity. Then the authority who passed the order is not having jurisdiction. Then any provisions of the Act is contrary to virus of the Constitution. So all these grounds should be there, and go through the judgment. It will facilitate you to file an appeal. Normally DRT, DRAT appeal, all these things are there. There also sometimes the courts entertain, sometimes court rejects. But during vacations, all these DRT orders are being challenged instead of approaching DRAT. And the courts, survival justice, used to grant relief by facilitating for depositing certain amounts to balancing both sides and give some relief. For all these things, the judgment may help you. Best wishes. And you all should understand that recently Justice Satish Kumar and Anand Venkatesan has delivered a judgment declaring that the powers under 122 CRPC awarding punishment for violation of bond executed under chapter 1 under 107 109 110 CRPC, the deputy commissioner power conferring on deputy commissioner to pass such punishment orders have been set aside, and we have to go through the entirety of judgment whether that power vested with the SDM, revenue authorities, subdivisional magistrate, divisional magistrate, district magistrate, is also been declared null and void or not, because the punishment, awarding punishment, is exclusive functions of the judiciary to have independency of judiciary, the basic fundamental object of the Constitution of India. Best wishes.